We have one case set at 10:30, and I will call that case State v. Borders, number 128-883. Counsel, you may approach.
Good morning, Mr. Chief Justice, and may it please the court. James Ladd of the Appellate Defender's Office representing Harlee Borders. I'm ready for argument, and Mr. Chief Justice, may I please reserve 3 minutes for rebuttal?
You may. Thank you, Mr. Ladd. You may proceed.
Proceed.
Let's let her.
Oh, I suppose, I don't mean to be rushed, but
Whatever the court wants, Your Honor.
yeah, no.
Please, court.
We don't need to hear from the state.
Good morning.
Please proceed. Sorry
The
about
state
that.
appears by Deputy District Attorney Jody Litvin, present, ready for argument.
Thank you, Ms. Lifkin. Thank you, and you may proceed.
So again, James Ladd of the Appellate Defender's Office representing Harlee Borders. I'm going to recap very quickly the procedural mechanism as we got here. I think we have a unusual issue that I hope this court finds interesting. This case, in its first appeal, this case came from a motion for summary disposition where I argue that Harlee Borders was represented by conflicted counsel in a motion to withdraw our pleas. The state agreed with that motion, and this court entered a dispositional order agreeing with the case law cited in their Preto and reversing defendant's convictions and reversing her sentence. And my argument on appeal,
Before we get there,
Yes, sir.
we can all agree that that's a mistake, right?
Yes,
Reversing of the conviction. You didn't ask for it. You were the attorney
that's right.
in that. You didn't ask for reversal.
That's correct.
But it made its way into the order. So we've got a mistake. So now you're trying to exploit that mistake in the arguments that you're making.
Yes, I am.
But the district court basically recognized it was a mistake as well. So isn't that the reality that we face? I mean, I appreciate you've got all these other issues and speedy trial and all that stuff, but it's all premised on an alternate reality because this is a mistake. So what do we do with the fact that this is a mistake?
My argument is that we have to live with it. And my reasoning for that is, I do want to be clear too. I did not ask for this court. I didn't try to trick this court into reversing her convictions. I didn't ask for that. That's just what happened. And since that happened, as representing Miss Borders, I need to do what I can to help her. And I saw that.
No, I understand that, but your motion after the mandate was issued did not include your requested relief was for a rehearing with conflict-free counsel on the motion to withdraw the plea. That's what you asked for.
Yes.
And how is that consistent with, why would you ask for that if the convictions had been reversed? There was nothing to plead to or nothing to hear. You did not ask for the relief you're seeking today.
That's correct. But this court reversed the convictions. That's what happened. Here's what should have happened. The state should have filed a motion for reconsideration for the dispositional order. And that never happened. And so now that's the law. As I go through at length in my brief, the district court doesn't have any exceptions. Maybe somebody could have filed a motion for modification or for clarification. But even then, I would still be arguing that the error is in the order. And I'm not aware of any case where this court has ever said we're going to sua sponte, go back and change an opinion or an order. Once that mandate issued, that is the reality we have to live in now. And this court reversed the convictions. The district court.
It says, well, if you're being that literal, it was a conviction. Which one?
Right. Well, the district court interpreted it as all convictions. And also this court in that same order, this court said reverse sentence, singular. But nobody's up here arguing that this court meant one sentence was reversed. Everybody understood that it was all the sentences. And again, everyone else could have done something as well. This is the adversarial process. I'm not going to tell the state that they missed something. They could have filed for rehearing. The district court or the state back on remand could have, as this court has suggested, could have possibly sought clarification. None of that was done. And so this says sentence. Why would this court reverse one conviction? I agree. But that's how the district court interpreted it, as convictions. And that's what happened. And the speedy trial clock clearly,
Interpret any, that's the problem with this case, counsel. We didn't interpret anything. It's just a mistake in an order. That's all it is. It's clearly a mistake. There were more than one conviction. It just says one. I would argue that you also have a role here to come back and say what's going on with this so that we know what to do when we get below. As opposed to saying, hey, maybe I got a new argument here.
I mean, I completely disagree. Why I would never do anything that would harm one of my clients. If I think something happened that I didn't lead this court into doing, even inadvertently, I didn't do that. I would never come back and do anything to my client that would harm them. If something positive, if at sentencing, if the district court imposes the wrong sentence and I know it, I am not going to speak up and go, excuse me, sir, please give my client the bigger sentence. I would never do that. That is my job here. I will never back down from that role as an advocate. Something happened, I saw it, and I'm trying to help my client the best I can. And I think the district court did interpret this torts order as all convictions. That's how they wrote it in the memorandum opinion. It had reverse convictions with an S, plural. And when the district court interpreted that, that's also my argument. That's the most reasonable interpretation. I understand why would this court reverse one conviction, and the district court agreed with that question and read it as all convictions. And once the district court interpreted it that way, my argument is that they had no choice but to then try to re-accept the pleas before the statutory speedy trial ran. And that's my argument today on that one. And even if this court says there's more fact findings, that's why I gave this court options of ineffective assistance of counsel and a Van Cleave hearing, to make sure we get that, to make sure I try to give as many possibilities as I can. If there's no more questions on that issue, I'll move on to my plea withdrawal issue.
Well, how do you understand that also the direction, at least in our order, was to agree that State v. Prado applies? State v. Prado didn't offer relief in terms of reversing convictions. It discussed conflict-free counsel, and you rehear the motion to withdraw the plea. That was the remedy in Prado. How is that? That's what we were doing.
Right, I understand. And so, I mean, I think the order, as I said in my issue too, it is ambiguous. But we have to make the most reasonable interpretation we can out of these orders, given the mandate rule has no exceptions. And the most reasonable interpretation there is, when you consider everything, is that this court reverse the convictions, because that's literally what it says. Or it says reverse resulting conviction. The district court interpret that as conviction.
Singular, counsel.
The district court?
That appellant's resulting conviction is reversed. It's singular.
Yes, I understand. Yes, in your order and the mandate, it is singular. The district court interpreted that as all convictions. And as soon as the district court interpreted it, my argument is that the court had to live with that. And the court had to either try to reaccept her convictions under the statute. And that was all that was left.
Is one possible, and I can anticipate already you'll argue this is a stretch, but I wanted to get your response. Is it possible to interpret the order as saying the convictions, plural, are reversed if there's a successful rehearing on the motion to withdraw the plea?
I guess I don't, I guess how are you getting there, Your Honor, if I may?
Well, I'm
ask?
just, that would be the that would be the normal course,
I'd say
right? If
it's
it was
always
sent
the-
back and there was a rehearing and the district court said, yeah, based on this rehearing, I think the defendant is entitled to withdraw her plea. That would nullify the convictions, right?
I'm sorry, I apologize. Can you say that again, Your Honor?
Well, okay, maybe I'm not being clear, or maybe I'm just wrong, but if this mistake, whatever we want to call it, wasn't there, it had been
Right.
sent back, there had been a new hearing, and the
Right.
pleas had been withdrawn by permission of the district court.
Right,
That would nullify the convictions, correct?
correct.
So couldn't we interpret the order, as poorly worded as it might be, which is what I think the district court interpreted it as saying the convictions would be reversed, vacated, if the plea was permitted to be withdrawn on remand?
Sure, I understand. I suppose that is one way you could put this order together. I think the most reasonable way to word it, to see it is this court didn't remand for only a plea withdrawal hearing. So what the court should have done is the court should have had another hearing to re-enter the pleas, and then after that conducted the withdrawal hearing. Or another way to view it could possibly, I mean, we can view this a million ways. Another way to view it could be that they reversed the convictions, but they left the plea agreement intact. And so now we're having some kind of hearing, and is there a frustration of purpose? Are we going to let the defendant out of the plea agreement?
So I'm just looking at the district court's footnote 1.
Right.
Which seems to me to be the important place to look in the record. And the district court says, interprets the mandate and the order as, quote, meaning defendant's convictions are also still valid pending the outcome of the court's ruling today. And I'm just asking, why isn't that a reasonable interpretation of the order and mandate?
Sure, my response would be because this court point blank said we reverse convictions. That's what this court said in the order. Convictions are reversed, or conviction is reversed, singular. That's the appellant's resulting conviction is reversed. That is what I'm reading. And this reminds me a little bit of the case this court just put out on Friday, where we try to read everything. You know, you were talking about reading everything in harmony with the jail credit statute. And this court made the point we do that if possible. I mean, the only possible way, you'd have to just delete this sentence to get a lot of these.
About our cases that talk about not only the literal, figurative, literal reading of the statute, but also the mandate, but the spirit of the mandate and the order. What about that? How does this capture the spirit of what was intended?
Sure, and my response would be that it also, looking at it from the other direction, is you would completely obliterate the spirit if you read out one sentence that says reversing resulting conviction. And so the spirit has to incorporate that sentence into it. And so we're trying to get the best reading we can. And my argument is that the district court interpreted as resulting convictions, and the district court then erred in saying that possibly they were going to keep them intact until the plea withdrawal hearing. That's my argument and my position on those issues.
Another possible solution, hypothetically at least, is to recognize an exception for obvious demonstrable error to the mandate rule. Is there, what would your position be in response to that possibility?
Sure, I think I have two responses. My first one would be the mandate's not erroneous. The order was, and the mandate just faithfully set forth what was written in the order. So my first response is the mandate's not erroneous. Then my second response would be that this court has not recognized any exceptions. In the statute, there aren't any exceptions, and I think it would be a dangerous road to go down if we're going to start making some exceptions of what's going to be argued on remand, trying to work best for our clients.
What about the alternative? We recognize in Sperry v. McCune our, quote, power to recall, correct, or modify our mandates.
Sure. I don't think that, as I was saying, I don't think that's helpful here because the mandate's not erroneous.
Wouldn't that be up to the judgment of the court?
Well, I would no, because you'd have to reverse the order. The statutes dealing with the mandate say that the mandate shall set forth what's put forth in this court's decision.
Do you think then that we do not have the inherent authority to correct our own order?
I do not, at this point, I do not think you do for the order.
And what would be your rationale for that?
That it's over and done with. The correct way to do it by the rules would have been to ask for reconsideration.
And we just can't sua sponte do that on our own motion.
For an order. I think you can do it for a mandate, but that's different because the mandate here is not erroneous. But when you have an order and opinion, I've never seen where this court has sua sponte, especially after the mandate's issued, has come back and said, we're going to correct this.
Doesn't our case law also suggest that you can't so easily separate the technical mandate from the decision itself?
Yes, it does.
And so doesn't that kind of cut against your analysis that there's no error in the mandate?
Well, I mean, I don't think so because I'm just working off the mandate that says that appellant's resulting conviction is reversed, which is what the mandate says. And so that's what I'm working off of there. I guess I don't.
Or what if it said it is not reversed? And the order said is, well, anyway, that would be the error that you were looking
Right.
for, I guess, but.
Yes, Sean. If there's no other question on that, I'll if I may very briefly address
Briefly.
plea withdrawal. Thank you. I just want to say very quickly that it's very easy to look at the Miss Borders' position as a third party. But I just want to ask this court to put yourselves in Miss Borders' position of an attorney saying, yes, let's enter this plea agreement without telling her I haven't looked into mitigating circumstances, without telling her I don't know if there will be any, or without telling her that she didn't know, that she probably didn't think there would ever be any. I think that's lackluster. And I think if we put ourselves in her shoes, we would want our attorneys to tell us that. And I think that'd be an interesting question to ask the state, is if they were in Miss Borders' shoes, would they want to know those things? And if not, then how can we say this is full luster when those things weren't done? And if there's no other questions, that's all I have. Thank you.
Good morning, Your Honors. May it please the court. Our position, I think the court has hit on here today, is that the phrase in the court's order, reverse appellant's resulting conviction, is a mistake. I think the most reasonable interpretation of the order, based on the remedy that was requested by the appellant, is that the convictions stood and that reversing them would go a step too far. What would be the point of the hearing if the convictions were already reversed? And I'm not actually sure that the court can give a remedy that wasn't asked for below, which the defendant here did not ask for anything to happen with the convictions. So our position is that the most reasonable interpretation of the order is that, and what the state agreed to under Prado, is that the defendant got a new hearing on the motion to withdraw the plea and got right back in the position that they were essentially.
Is that an interpretation of the order, or is that a rewriting of the order?
I think it's an interpretation, Your Honor.
In other words, if we start where you started, which is this is a mistake, do we really allow interpretations to write mistakes out of things? I'm just looking for what's the proper way to, from the state's point of view, to handle this. Is it really to give district courts the power to rewrite mandates?
I don't think that you have to go as far as to say that the district court can rewrite mandates. I think that looking at this order on its face, you have to take into context everything that was done with the appeal before, what was requested, what the state agreed to, which makes the state hesitant to,
Well,
kind of.
The spirit behind my question is the reason I think that we have a bright line mandate rule is that we don't want people doing what you're suggesting. Saying, oh, that's not exactly what they meant. Look at the context. It's, you understand what I'm asking.
Yes. And I don't think this is a rewriting of the court's order, because I think the court's order says all of the things and adds one thing that is clearly not, included, should not be included. So I don't think you're rewriting anything to say, reverse the denial of the pre-sentencing motions for new counsel. Yes, that's what they asked for. And to withdraw her plea, to vacate the sentence, which you have to do in order to get that new, to bring her back to the pre-sentencing motion to withdraw plea hearing she asked for, and remand for appointment of new counsel and a hearing on the pro se motion to withdraw her plea. So we're not rewriting any of that language. You're just interpreting a phrase that shouldn't be there, which I don't think is rewriting.
Striking it out, right?
Yeah.
Okay.
And I don't think that's unreasonable. And I don't think that's rewriting the order. I think if that was just in there alone and this court said, reverse resulting conviction and nothing else, we would have to rewrite. Then there would be.
Is there any other resolution that the state would find that from your position would be the correct outcome other than what you're asking us to do, which is let the district court strike those words out of the mandate?
I think your Honor's interpretation of, you could interpret this to say reverse resulting conviction if the motion was granted.
Is that your understanding of footnote 1 in the order?
I don't think that the district court interprets this court's order to say conviction versus convictions at all.
I agree. I'm asking about footnote 1's suggestion that as of that moment, the convictions are valid, but that's pending the outcome of the rehearing.
Yes. I don't think the district court explicitly says anything about what this court's order, that phrase. But it's just, my interpretation of the court's order is, what are we doing here for this hearing if the plea is not presently intact? What would we be withdrawing? You know, so, and although it is true that the state did not do anything with this language, that pointed the defendant right there to an opportunity to say, oh, I can argue that the convictions are reversed, and that didn't happen below. I think it's pretty clear from the record below that the parties and the court understood the procedural posture of the case, notwithstanding the language in the order, and that her opportunity to re-argue her pre-sentencing motion to withdraw a plea with conflict-free counsel was what they were there for. And I don't think anybody had a problem with that remedy, considering that's what was asked for and what was agreed to by the state. If this court wants me to move to the third issue, we would agree that, or we would argue that for the second issue too, that all depends on the reasonableness of the order, and we would incorporate those arguments into that issue as well. But for the third issue, our position is that the district court correctly denied the motion to withdraw her plea and found that the defendant did not establish good cause to withdraw her plea. As I said, the parties agreed that the Edgar factors are what controls here. This court looks for an abuse of discretion. Those three factors that the court went through were whether the defendant was represented by competent counsel, whether she was misled, coerced, mistreated, or unfairly taken advantage of, and whether the plea was fairly understandingly made. The district court's written order here went through each of those factors and denied them, found that she did understand her sentence. To me, the state's position here is really that the defendant waffled on whether she wanted to withdraw her plea. It almost seemed as though she just wanted another chance to present her substantial and compelling factors. That doesn't mean that her counsel below did not investigate those. That means that she was not, satisfied with the outcome of those and wanted to really have another shot at arguing for her departure. I think that the evidence that was taken at the hearing supported the fact that she knew that it was a hard 50 sentence and they had the opportunity to ask for a hard 25 if there were substantial and compelling reasons established. And I think the district court made credibility findings under each one of those factors that this court cannot now go back and reweigh, and I think they were supported.
It seems like her argument is that absent some sort of mitigation evidence or investigation, I should say, prior to entering the plea, she in fact believed that counsel believed that she had no chance at a departure. And that's kind of her position, that absent that investigation, how could she know that she even had a chance? Is that how you understand her position? I mean, that is hinging on the fact that trial counsel didn't do any kind of mitigation investigation in the circumstance if she takes this plea and pleads to the crime as charged.
Right. I think that's an accurate representation of what I think she thought. Before I even plea, we have to have my substantial and compelling factors already laid out. I have to know what we're going to argue and know my chances, right, which I don't believe is the case. And I don't believe you can know at that point in time what counsel is investigating, because counsel's testimony was she was always looking for things to help in the case, always looking for, I don't think she called them substantial and compelling factors, but we're always looking for points of help. And she was investigating several things during the pendency of the case. So I don't think that you have to have those all lined out before she pled. And I don't think that the testimony supports that was she did nothing whatsoever over the course of the case. And I don't think the testimony supports that she didn't know what her standard sentence was and have the opportunity to ask for the hard 25, because that's actually what the plea agreement said as well.
And then she made an argument at the sentencing about the hard 25 and mitigating factors
In the original,
in the original sentence.
yes.
Yes.
There wasn't an expert like in the second sentencing, or there wasn't, I think as much as the defendant wanted, but she did make those, and then also had the defendant testify about some of her abuse that she suffered, and, had her talk about how remorseful she was and apologize, and those things, which are also go to the substantial and compelling factors too for a departure.
It may not be possible to conduct the mitigation investigation at the time of plea negotiation. I understand that argument, but there probably should be some communication about, in the absence of that, and you're negotiating as part of this deal, a right to bring forth a departure motion and some assessment of the likelihood of those motions being successful. What is the nature of this right that you are actually negotiating for? Is there evidence in the record that that sort of advisement happened?
What I'm recalling, Your Honor, I don't know that there was that sort of assessment. What I'm recalling is defense counsel's testimony that she doesn't ever give odds. She doesn't ever say you're likely to get this or not. I think it was the presumptive sentence is a hard 50. We have the opportunity to argue for a hard 25. And also, since they're not all statutory, you can take things that aren't in the statute. It's hard to say whether they could, what you can come up with at that point in time. But I don't know that there was like a chances, I think she said, I don't give people chance, I don't like to speculate on their chances of getting a departure. And if the court doesn't have any further questions, I don't think I have any further presentation. We would just ask the court not to address issues 1 and 2 as they weren't preserved. The reasonableness of the order would be that the convictions stand, and then to affirm the district court's denial of her motion to withdraw plea.
Thank you, Ms. Litt.
May it please the court. I just want to be clear on my arguments for withdrawal of plea. My first main argument is that there was no investigation done before, and that under these circumstances, that is absolutely necessary. Why would you ever enter a plea on a life sentence when you don't know whether or not, when substantial compelling reasons are required?
Doesn't that happen all the time? Are you suggesting that has to be a complete understanding and investigation of the possibility of mitigation success prior to entering a plea? I mean, how can you do that? And when counsel talked about she doesn't give odds, trial counsel doesn't get, isn't that the responsible thing to do? You can't predict what's going to happen.
Sorry. Yes, I agree you shouldn't give odds, but I think when there's a life sentence, and that's what the case law says. It says reasonable investigation. I don't think you have to do an exhaustive one, but you should figure out whether or not reasonably you think you can get a substantial, you can find substantial compelling reasons for a departure. All that's left after a plea is sentencing. You got to do it sometime, so why don't you just do it before the plea, the investigation into mitigation? And then my second main argument is I'm not asking the trial counsel to give odds. I just want them to inform them. If you read them the law and say this is what the law allows, you're going to think that's what it allows. But if you don't know whether or not she knew the facts of this case. The facts of this case, let's be honest, were horrific. She should have said, I believe, I don't think you're going to be able to get this, or I don't know whether or not you can get this. Otherwise, how can it be annoying, and how can it be annoying if you don't know whether or not you have a chance at getting the substantial and compelling reasons? I just don't see how it's enough to just go, maybe. Here's what the law says. Maybe you can get this. That's my position on that. And if there's any questions, Your Honors, I'd be happy to stand for them. Thank you very much.
Thank you, Mr. Latta.
Thank you.
That concludes this morning's docket. Court will be in recess until 9 a.m. tomorrow morning.